Let's freaking go, people. AR bans back on the menu, this time in a new district court that's been reinvigorated with new appointees. Republican advantage, creating the disparity between different circuit courts that Kavanaugh was asking for. Who's ready for AR bans to die forever? It's a step. It's not the final one. But this one you gotta know. Everything is linked in the description box below. This just happened about an hour ago. And of course, if you were down for that fight with the Second Amendment, you want to kick gun controllers proverbially in the gonads, make sure you hit that like button, subscribe to the channel, turn the notification bell on because we are leading the charge and we intend to do just that. Let's get it. All right, people. Every time that you hit that subscribe button, you make them cry. Let's do it. All right. At Braden LOA, you guys know. Check this out. All right, this is coming from Hannah Hill. Now, Hannah Hill is affiliated with NAGR. She's citing an FPC statement around some breaking announcements that just happened around AR bans. Let's get it. Y'all, this is our best shot at a circuit split on AR-15 bans. The Third Circuit is now 7-6 Republican appointees versus Dem appointees with the confirmation of Judge Emil Beauvais. This is a really big thing, okay? I'm going to go to this in a second from FPC, but let me show you some history on why this is important. Because I'm not just going to tell you what's going on. I'm going to tell you how we're going to fix it, and I'm going to tell you why this is important. All right? You guys remember this. Okay, this was back in June. Kavanaugh has signaled that the Supreme Court will soon be deciding the constitutionality of banning AR-15s. You guys know all the facts. You know the fact that AR-15s are more common in the United States than Ford F-150s. You know that they're the most popular rifle in America. These are not unknowns to you guys. However, when you look at all the percolation that's happening, that word's going to come back in a second, it matters. Watch this. Again, this is from The Hill. Everything is linked in the description box below. The Supreme Court on Monday declined to take up a case that involves whether possessing AR-15 is protected by the Second Amendment, but the court's conservatives are signaling they soon will be. You know that the Maryland case didn't get taken up. It got denied cert. But the reason it got denied cert is important. Of course, it barely fell short of the 4 votes required to take up the case because 3 justices actually voted to do it. Those justices, by the way, were Thomas, Alito, and Gorsuch. But Justice... wait, what? That's a typo. In my view, this court should and presumably will address the AR-15 issue soon. In the next term or two, Kavanaugh wrote in a 3-page written statement. Now, that's the next year. So this was in June. So that means 2026, 2027, hypothetically. Okay? That's what he's referencing. But he wanted to let it percolate. That word is going to be very prominent as we go forward. Percolation. Okay? Again, it's all about different circuit courts and creating disparities and contrast with each other. That's why the SCOTUS looks for these things. The 4th U.S. Circuit Court of Appeals upheld Maryland's law by ruling AR-15s are not constitutionally protected arms under the Second Amendment, which is, of course, ludicrous, insane, and stupid. The Supreme Court's refusal to hear the case leaves intact the ruling. That's the important piece. That's why this is such an important piece to this. Even Thomas alluded to it. I would not wait to decide whether the government can ban the most popular rifle in America. That question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade, Thomas wrote in a solo written dissent. You guys know all of these things. But Kavanaugh said he wanted to let it percolate through different district courts. That's important. Maryland, New Jersey, California, all of these things are all coming together in what I like to call a tapestry, okay? Now let's go back to the FPC announcement. FPC legal alert. Nearly 2 months after oral arguments at the 3-judge panel, the Third Circuit has decided to take our lawsuit challenging New Jersey's assault weapon ban en banc with oral arguments on October 15th. So that's happening this coming October. You know I'll be there listening to that one. But the reason this is important and what's changed here is what Hannah Hill highlights. It's now a 7-6 Republican appointee in the Third Circuit. That's why the Dems were walking out in the Senate. That's why they were doing all of the theatrics, because they knew that they were going to lose the Third Circuit. One of the 10 circuits, I can't remember the exact number, but one of the circuits, that's really important. I believe it's 10. That's really important. Because if they've lost the circuit, that means they've lost an entire region of the country. Really big deal. Let me get you into the actual documentation. Now, this is from FPC. I'm going to show you the actual announcement. On 8/21, that is today, the order to have a rehearing en banc, the oral arguments were on July 1st. So it's recent. This is not a really old long-term thing. And then, of course, oral arguments are scheduled for 10/15. This is a really important one, guys. This is a really important one. Let me show you the actual asset that they're referencing. Association of New Jersey Rifle and Pistol Clubs Incorporated, Attorney versus Attorney General in New Jersey, the Superintendent of New Jersey State Police, wow. And then all the proper people who are getting sued. That, you can read it. I got it all linked. But basically, the court orders a rehearing en banc in the above captioned cases. The clerk of court shall list this matter for Wednesday, October 15th, 2025, beginning at 9:30 a.m. in Philadelphia, Pennsylvania, dated August 21st. This is a really big piece, guys, and I'm going to go back to what Hannah said. This is a really big piece to this argument. Because as you look at all the different en banc hearings and en banc panels and all of these huge pieces that they always weaponize against us in the 2A space, to be quite candid, we have a 7-6 Republican appointee advantage in the Third Circuit now that one of Trump's judges just got put on there. That's a really important piece to this. And now, zoom out a little bit. See what I did there with the camera angle change and the zoom out? You guys get it. All right. If you're looking at our AR fight, if you're looking at the gun control fight in general, we are pushing and pushing and pushing and pushing towards the ultimate finality of the Supreme Court where we have the advantage. You can say that certain ones are sellouts. You can say certain ones are turncoats. You can say certain ones are cowards. The bottom line is, on paper, we have the advantage. Okay? As you go up this road, AR bans are particularly vulnerable. And the reason that they're particularly vulnerable is because there are more of them in the United States than Ford F-150s. They are by far the most popular rifle on the entire face of the planet. Maybe not planet, because you got all the different factions of AKs. Let's just stick to the United States. They are by far the most popular rifle in the United States. In the Heller decision, the common use test comes down and says, yep, you can't ban something that's in common use. That's it. Game over, case closed, check please. That's why they're sticking these things to the circuit court. That's why it was so important for us to get into the Maryland case in front of the SCOTUS. We missed it by one vote. Kavanaugh, the guy who actually delivered that one disappointment vote, is the one that says, well, we need some more percolation from different cases so we have the full gambit to fully decide. Okay, that's a sellout position. That's kind of crap in my opinion. You have more than an ample reason or evidence to go forward and do that. But now you've got the Third Circuit that's taking the case en banc, and it's going to be appealed to the SCOTUS in either scenario. That's what's going to happen next. Then you've got Maryland, you got New Jersey, you got California, you got Illinois. All of these cases are going up, and now you have a very percolated environment for a perky little cup of freedom coffee. And that's what I've got for you guys. Let me know what you think in the comments below. I'll see you later. I'm Braden.